is what it is. So, okay, well, we're coming up. Yeah. Stand by. All right, I guess we're ready. Well, good morning, everyone. I think we're now, it is 8:30 plus, and it is time for the Board of Adjustment to convene. We're happy all of you are with us today, and we look forward to hearing your cases, which will be called in just a few minutes. We would ask everyone to please turn your phone off or put it on silent. That really will be a real big help to everyone. And so, having said that, good morning. The meeting of the Escambia County Board of Adjustment for March the 20th, 2024 is hereby called to order with 6 members present. So we're glad to have all our members with us. And will the clerk please swear in members of the staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of the staff's resumes have previously been provided and remain on file for reference. The board has previously recognized the staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The BOA meeting package for March the 20th, 2024, with the Development Services staff findings of fact has previously been provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do I have a motion?
Motion.
I have a motion. Do I have a second?
Second.
I do have a second. All those in favor of the motion, please raise your right hand. The motion passes unanimously with all members in favor of it. Madam Clerk, do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
The chair will now entertain a motion to waive the reading of this legal advertisement.
So moved, Mr. Chairman.
We
Second.
have a motion from the,
Second.
and also we have a second. All those in favor, please raise your right hand. The motion passes unanimously with all members voting in favor of the motion. Members of the board, have you reviewed the resume and transcript for the Board of Adjustment meeting held on January the 17th, 2024? Upon your review of the resume and the transcript, are there any additions, deletions, or corrections? Seeing none. The board will now entertain a motion regarding the hearing resume for the Board of Adjustment meeting held on January the 17th, 2024. Do I have a motion?
Motion.
I have a motion. Do I have a second?
Second.
I have a second. All those in favor of the motion, please raise your right hand. Let the record reflect the motion passes with all members voting in favor of the motion. And now we come to the purpose of the Board of Adjustment and how the conduct of this meeting will be accomplished with, and we'll hear from our Vice Chairman.
Do you have it?
Well, and the circus immediately falls apart.
I don't have it.
And we were doing so good.
It's right there, at the purpose of the
Oh, okay. All right.
Okay. Purpose of the Board of Adjustments and conduct of the meeting. The Board of Adjustments hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for properties in accordance with the decisions of the BOA. However, if applicant requests the issuance of any such order or permit, and such order or permit is issued, the applicant and not the county shall bear any risk that such decision may be set aside. The development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. Any applicant for relief from a decision of the BOA for said actions, or any aggrieved party as defined by state law, may seek review of such decision by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form and submit it to the clerk of board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed requests to speak forms. We must have these completed forms for public record. Ex parte communication. All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission. Resolution 96-13. Before a decision by this board on any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication.
Thank you. We now turn to our first case. It's case number CU 2024-04, 1800 Patricia Avenue. It is a conditional use. It has been requested by Meredith Bush, agent for Ernest Commercial Investments LLC, the owner. And I see Ms. Bush is with us. Good morning.
Good morning, members of the board. Yes, we're here requesting an approval for liquor sales within a restaurant in the low-density mixed-use zoning district. I'm happy to go through our presentation and report. Mr. Jones has advised that this may be eligible for an expedited process since county staff is in agreement with the findings, and we've already been through a rezoning hearing outlining the proposed use. But if you wish, I'm happy to go through the criteria.
Generally, we would, the board has by custom heard a sometimes abbreviated presentation, but we would, I'm speaking for the board, I hope, we would like to go through the presentation.
Okay.
Before you get started, let me be sure, board members, we haven't had any ex parte communications regarding this case, have we? Now would be the time to announce that. Has anyone gained any knowledge or information obtained from a site visit or other sources? I see none for the record. Will any board member intend to refrain from voting due to a voting conflict of interest? And I see none there. And Ms. Bush, would you like to make a presentation, or would you prefer that the staff present its findings and then add whatever additional information you like?
It's really the will of the board. I mean, I can be very brief on hitting the high points, but it's whatever the board prefers.
I'll tell you what, let us hear from the staff, and
Okay.
then we will come back to you. Thank
Okay,
you.
Thank you.
Andrew?
Allison?
Yes. Okay. Good morning, Allison Lindsay, Urban Planner Development Services. So this is the case conditional use 2024-04 at 1800 Patricia, and they are requesting the conditional use for alcohol or liquor sales. So this is the location map showing the location on Patricia. This is the 500 radius zoning map showing the zoning currently LDMU and a small portion of LDR. This is the future land use map showing mixed use suburban. This is existing land use showing the parcel and the surrounding areas. This is our wetlands map. As you noticed, a lot of the parcel have wetlands on the around the subject. This is the aerial photography showing the site. And this is our public hearing sign that's posted on site on Patricia. And this is looking onto the subject property across Patricia. This is looking from the subject parking lot across Patricia. This is looking south along Patricia from the subject site. Looking north along Patricia from the property, and that's the maps and photographies. So as it was stated earlier, this case, it did meet all the criteria. So just kind of briefly, the 2.68 plus or minus parcel, it's on Patricia, which is on a local road. And they are proposing to sell liquor in an established restaurant. And there will be, currently there is wetlands that could act as a buffer between this parcel and the low-density residential to the north. So for the facilities and services, they are available through ECUA and also solid waste. They will have all on-site solid containers will be located on the site and have access, limited off-site visibility. Ingress, egress will be from the existing connection on Patricia. And this property, as far as nuisance and hazards, it will have the operating hours of a restaurant, and it shouldn't have any unreasonable noise, glare, smoke, or dust for any of the surrounding properties. Screening and buffering, as mentioned, they must meet all screening and buffering requirements of the Land Development Code, and the wetlands that are located will remain and serve as a buffer. So any signs and lighting, it will also be reviewed during the development review process, and will have, any exterior lighting shall be deflected from any adjacent properties or public right-of-ways. The site characteristics, the location was previously a bar, but it has not been in operation for some time. The location appears adequate for the scale of the proposed use and the specific county requirements. The use requirements, the parcel is low-density mixed-use zoning, which does allow for restaurants, including on-premise consumption of alcohol, and this request is just to include the sale of liquor. And the staff findings, we do recommend the approval of this conditional use.
And just as a reminder for everyone, when they do come in for the license, to add liquor sales on their alcohol license, staff will do the usual search for any place of worship, daycare, schools within 1,000 feet.
Do we have,
Which also was not noted just by staff doing the pictures and the site visit, that no schools or daycares or churches were noticed within 1,000 feet.
does the board have any questions, any board members?
I have clarification, because I was confused on this. It's zoned low-density mixed use, and according to one of the pages that we got, there's a permitted use for restaurants, including on-premise consumption of alcohol, but excluding drive-in or drive-through service. This liquor sales, is it like a liquor store that they're wanting?
Off premises?
I believe they also want to sell liquor at the establishment, not just for on-premise consumption. But the applicant can verify that, but that's our understanding. So the conditional use is for the sale of liquor.
Off premises.
Yes,
Okay, so like a liquor store.
yes.
Okay,
So they'll have a restaurant / bar, and then they'll be able to sell like a package store.
Okay,
So the
and-
zoning under the permitted uses, under retails, it does allow for sales of beer and wine, but it excludes sales of liquor or motor vehicles. And that's why it gets bumped down to a conditional use.
okay, yeah, that always throws me, because I think wine and beer are also alcohol.
Same active ingredient, just different concentration. Yeah, but that's the way the code's written.
Okay, so it's because they're selling, what I would consider hard liquor, but is it on premise or off premise?
Well, they're having a restaurant, so they can have on-premise consumption. Because the low-density mixed use allows for that. However, the liquor sales is the conditional use.
Okay,
Because they're different licenses.
Yeah. Well, I'll tell you what, I think Mrs. Bush in just a second will be coming up, and I'm sure she will give us a more detailed answer. I have one question also. How far is it from the housing development to the to the proposed site?
Okay, so on the screen, you see the aerial photo of a site. If you look up to the northwest, that's a mobile home park. And then there's the houses up there, up to the north on the other side of that wetland. Now, can you put the wetlands map on for me? So you'll see the wetland map encompasses a lot of that. So that's a all-natural buffer between those residential houses on Moore Avenue. So that is a distance. So I can't tell you the exact distance, but then down to the south on Fairfield, there's no houses on the other side up till you get to the Fairfield.
I guess another question is for me then, is that going to be perpetually a wooded area, or will it be available in coming years or time for housing development?
No, sir.
No, sir, no, sir. Those areas.
Mr. Jones, have you been?
Yes, I have.
Okay.
Yes, sir, yes,
All
sir,
right.
yes, sir. That area is fully buffered. When I said those are state Jewish wetlands, I go by there every Sunday morning, and that property been intact for a long time. You are not going to be able to develop on that at all. I mean, it is so. If they do it, it will cost an exorbitant amount of money because those are all under DEP Army Corps, all of it.
Well, you know, one thing we don't want to create is a coming to the nuisance situation and alcohol and homeowners back to back usually is not been a happy combination a lot of times. So that was my concern.
And I also noted that it said hours of operation for the restaurant, so it's not like it's gonna be open, 12 midnight, 2 o'clock in the morning like a bar would, I would assume. But the applicants here again can address that.
Are there any more questions for the staff from any other board member?
can you scroll up? I want to see the zoning maps again. Because you said something that confused me. Okay, so we got low-density mixed use. Now, it was a restaurant previously. Was the zoning the same at that time?
The zone, from 2015, we had the repeal and replace for zoning, so on the previous zoning was R2, I believe, so it was there prior to the zoning, I believe, because it's been there for a long time, I think.
Okay, and then the next slide. Okay, the future land use is mixed-use suburban, right?
Yes.
And then the next slide.
That shows the parcel in question in red, and then the surroundings, as you see, most of them are vacant because a lot of the wetlands, and then across the street.
What does it say, vacant commercial?
So it's, the building currently, according to the property appraiser, it's a commercial building, predated the code. And currently, I can pull it up.
I think that's how the property appraiser classified it when they probably did their appraisal.
Yeah, they had it as a nightclub, but it's currently not in operation.
Okay, so that really has no bearing on the actual zoning.
Correct.
Okay.
So the previous zoning, it was split.
Right.
It had R2 in the top and then SDD, which was Special Development District, basically because of all the wetlands.
Right.
And that was sort of an organic shape, so it was split zoned by that.
Right.
Because that is quite a bit of wetlands in that area.
And the low-density mixed use, can you read the purpose of the low-density mixed use at paragraph A for me?
Low-density mixed-use district establishes appropriate areas and land use regulations for a complementary mix of low-density residential uses and compatible non-residential uses within mostly suburban areas. The primary intent of the district is to provide for a mix of neighborhood-scale retail sales, services, and professional offices with greater dwelling unit density and diversity than the low-density residential district. Additionally, the LDMU district is intended to rely on a pattern of well-connected streets and provide for the separation of suburban uses from more dense and intense urban uses. Residential uses within the district include most forms of single-family, two-family, and multifamily dwellings.
Okay. I was just trying to wrap my head around all that.
Sure.
Thank you.
I have a question. The parcels across the street, we discussed the ones on the side of the street where the applicant is property. Are those also subject to development, or are they perpetually going to be wetlands?
You mean the ones right across the street in the wetland areas?
Yes, the ones
Here
that,
again, they're wetlands and they would have to be by the Corps or DEP, so they have strict requirements and restrictions.
Yes,
And-
sir. It
And there
appears
may
that-
not be enough uplands to build.
It appears that that is a contiguous type of wetlands, but it's all connected. It's all connected to that huge wetland
right,
land field. Yes, sir. Like Allison stated, that small portion of what's on the map that possibly uplands, and maybe more than that, that's really an undevelopable area.
And Patricia Road Drive is considered a local road, is that correct?
Yes.
And Fairfield is a minor arterial?
Yes.
I've never,
Yes,
I don't
ma'am.
think I've ever been on Patricia. When I think of local road, I think of like a residential street.
Yeah, if you go further up Patricia to the north, where those subdivisions start, that's more where the residential starts, and it goes into Cerny, I believe. It's the next major road that goes to east and west. And so there's not really any residential development south of this parcel. Because even on the other side of Fairfield, there's all businesses, Fairfield and Patricia.
Okay, that's a business.
Yeah, there's a
Area.
used car, there's repair shops, there's a barber shop.
Okay.
are there any other questions for the staff from the board members? Ms. Bush, Mrs. Bush, would you like to help us also?
Sure, I'm happy to address some of your concerns. So if you'll pull up page 7 of our report we submitted, it's the photograph of the buildings on site. So you'll see here in the existing development, this is the old Anglers Restaurant and Lounge. It's been out of operation for a number of years, but there are 2 buildings. One would be the restaurant, the other would be a liquor sales or package type store.
And what about the hours for this package store? And
I have a representative here from the development, if you'll allow me just to ask her briefly.
yeah.
So the package store may be 10 a.m. to midnight.
7 days a week or 5 days a week or
I'm
what?
assuming 7 days a week, whatever the county would allow.
Okay.
And, notice was sent to all the surrounding areas, and we received nothing but positive comments from the neighborhood requesting that, excited that the restaurant was coming back and that the liquor sales were going in.
Okay, all right. And board members, Mrs. Bush, are there any specific questions before she makes her remarks that you might have?
So, once again, we are deciding not on the restaurant, but to allow a liquor store here, basically.
Liquor sales, yes, ma'am.
Correct. The restaurant's permitted as right,
Right,
which allows for the sale of alcohol for consumption with the meal.
right, exactly. And I got that, and you're allowed to do that all day long. You don't have to come see us for nothing. But the liquor store is why we're here today, right? Drew?
Yes.
Sorry. The code isn't 100% perfect in every way, as we know. When you look for, as I read to you from retail sales, it excluded liquor sales. When you get to the conditional use, number 2 under retail sales, it just says liquor sales, okay?
Right.
There are different licenses with the state. There's, for whatever reason, beer and wine get treated differently.
I disagree.
Well, like I said, same active ingredient, but that is the way it's written,
Right.
based on those licensing requirements. So let's say they have strictly a restaurant, they have a beer and wine license, they want to add a license to allow liquor. Well, at that point, then because the code doesn't specify if it's a restaurant this, if it's a package store that, it just simply says liquor sales.
I'm like the vice chairman on my concern, and maybe Ms. Bush, I'm sure, will help us further on this. We actually have 2 cases here. The restaurant and the sale of, I'll say, hard liquor with, as part of a meal, is one thing. It's another thing to have a separate building in which essentially is going to be a liquor store. And they've been joined together in this application. And would like to learn more, I guess, about the liquor store.
If I may, Mr. Godwin, we really do not have 2 separate cases. The code is clear. The code is black and white. Now, if there's any interpretation that is needed, that's a separate process for that. But as far as what we're deciding today, as Drew stated, the code allows for restaurants. Period. That's,
We don't-
That is the use. Let me finish with my train of thought. By right. Now, the code, it may not be written as it should be, but it clearly says liquor sales, which allows for conditional use approval. Now, the state rules, Ms. Bass, I'm not a drinker, so I don't get into all that, but the state is what governs the type of licenses, whether it's beer and wine, they say that's a little different. But when they come to those, it's 4 COP, 2 COPs, there's a different type of procedures. And our code address that as well. Our code says, but
Right.
the distinction was made because restaurants beer and wine. Now, there's some process, they gotta go through that, the code talks about that. There's another process in the code about that. But with liquor sales, because of the low-density mixed-use requirement, they want to make that a condition, just in case, if there are some citizens that may have some concerns. That's why it's for conditional use approval for, but uses that has the potential for adverse impact, and we know that sometimes it does. Just because of being in two separate buildings is really, it's the same, just like there could be an Applebee's, they gotta come into the same thing with us. If they have bars in their thing,
Right.
they gotta come and see us.
I don't, well,
So-
Mr. Jones, I don't have really too much of an issue with inside restaurant sales of the alcoholic beverages. My concern is this separate, we have a separate facility that's going to be a package store in effect, and which is a different deal. Do you know by any chance, are these two separate legal entities?
No, it's all owned by Everest Commercial. It would be operated by the same individual, Mr. John Truskowski, who owns and operates establishments of this nature throughout the county. He's very well known in the community, has been before the various boards several different times, and runs a good solid business.
Okay.
Sites can, we see it all the time through our site plan process. Sites can have different uses on one parcel. And that's,
Well,
they have multiple uses. That's why we have these regulations on these type of uses that has the potential to coexist on the same site. We see that's all over the place, and so that's why we have separate rules for certain type of uses that may be on the same parcel of land.
So when I'm looking at the code, under low-density mixed use, alcohol is not the same as liquor.
It is under, when you look at retail services, restaurants, including on-premises consumption of alcohol, that includes all alcohol for the restaurants. So
Right.
restaurants can serve both beer, wine, and hard liquor. So it's already, as of right, under subparagraph 3E.
Okay, so the only reason we're here is because of
The liquor
the package
sales.
store.
Yes.
Of the package.
Yes.
store.
Correct.
That's-
So-
Well, it's, the way that it was presented though, and this is not understand this is not a criticism of your presentation at all. This is directed at the staff, but when I read it, the emphasis was, this is a restaurant that wants to sell
Liquor.
hard liquor.
Yes, and
That's
that's
not
my
the-
assumption.
That's not the case.
Correct.
This is an application for a package store.
Right, right.
In which there is a restaurant that will also be selling hard
Which is
liquor.
regardless of this issue.
Yeah.
Doesn't matter if
So
it's-
and again, I'm not being critical of the staff either, and I don't want, because undoubtedly Andrew and Mr. Jones and
And
his
Rachel.
analysts are some of the finest planners that I've ever known, that's for sure, and they
Respect you,
do
no
wonderful work.
No problem.
But this was not presented, I just have to tell you, when I read it last night, that's not, until Ms. Bush got up here and explained it again, it wasn't presented as to what we're dealing with here. And the question in my mind, and I could be wrong, and I'd like to hear from the board, the question is whether or not we're going to permit a package store to sell hard liquor.
And that's why I wanted Drew to read the purpose of the low-density mixed-use district for everyone to hear, because if we're talking about a package store, to me, that's a different light that I shine on this type of zoning as opposed to a restaurant that sells
Mixed drinks.
mixed drinks? Thank you.
It's an entirely different game. Now, I would like, you've heard the vice chairman and you've heard me, but I would like to hear some other thoughts, because it's important that everyone on the board feels
do you wanna have
like
Ms.
they
Bush?
they have thoughts.
Do you want to have Ms. Bush do her presentation first?
Yeah, Ms. Bush,
Sorry,
I'm sorry.
we have
I've
not given
not been
Time.
I won't say treating you the way I should, but I'm certainly not, I'm kind of ignoring you, and I'm not really. We get all wrapped up, and sometimes, it's best that,
Mr. Chairman, before Ms. Bush's presentation, I would just ask the board to consider, since they already sell liquor, alcohol, what difference does it make if it's a package store? Is my question.
well, to me, it is a different, an entirely different situation from a restaurant. It's not the same level of, I won't say intensity, that's not the word I'm looking for, but it's not the same kind of thing we're talking about. It's one thing to sit down, go to a restaurant, order a drink, and have a meal. It's another thing to drive into a liquor store with all the attendant issues that sometimes develop with that sort of availability. That to me is an entirely different kind of situation.
And the fact that it's on a local road, concerns me, because to me, a local road is more of a residential thoroughfare, if you will, as opposed to 9 Mile Road or Fairfield or, that sort of thing.
Duly noted, thank you.
Marty, did you have?
Yes, if I understand what's been said, the package store would require a different liquor license than the restaurant, is that correct?
That is correct.
That is correct.
Just
Yeah.
so you know, with all the different licenses and the distinctions between them, our code makes a definite distinction between a beer and wine license and a liquor license. Let's take the occasion. This isn't the case here, but the board has heard many of these in the past. If, let's say you've got a CVS, Walgreens, what have you. They have a license. It is for off-premise beer and wine sales. The code doesn't prohibit that within that 1,000-foot requirement for churches, schools, daycares. What it does prohibit is liquor sales for off-premise. Same, like I said, beer and wine, you can do that. Liquor, you can't. Then it becomes a conditional use. To do the exact same thing, it's just when you add that extra product to it is what kicks it over. So this is just another example of the code pulling that one type of alcohol separate from the others.
So,
Clear as mud, I know.
And also too, if the buildings were connected, it could be the same outcome if the buildings were connected. Again, it's one site with multiple uses. It's the site. Now, if there's any concern over the zoning classification of the code, that is a different process. Now, let's say they do, and let's say they need a full COP. That's what in my mind. There's another process for that. They gotta come back to see us. If there's any churches or schools or daycares, schools completely out loud, no, it's a prohibition. If there's a school within a 1,000-foot radius, if there's churches or something, they will have to see this board again for that. It depends upon the license type when they come and see us. So, but this is for this, to get this use there, that the board, the intent was to say, hey, there could be some neighbors who are concerned with having liquor sales in a low-density mixed use. Let's have conditional use approval for, so that the neighbors can show up if there's concern, because it has the potential. It has the potential for that. It is separate. But the low-density mixed use, it does allow for this to come through, a conditional use approval. The road type of Patricia, that's really, it's of concern, but it's really because we don't get through traffic patterns. Patricia could be functioning as a minor artery because of the traffic pattern. So just because it's a local road, that still don't mean it's not functioning as a road where it's traveled. People come back and forth. So those type of issues, sometimes it takes another process to determine that site plan review process for that. But on this, we're just looking at if it meets the conditional use approval to have this type of sales in low density mixed use, whether it's in the same building or on the same parcel.
Let me finish
Yes, sir.
my question. Because the state would require a separate license for the package store, does that mean that this board would have to, the county would have to approve the request before they could issue a license for packaged goods?
Correct. For the staff to sign off on the zoning, for liquor sales, the code does require it be a conditional use.
Absolutely.
Yes, sir.
Yes, it does.
Mr. Chairman, if he's done with his question, I just had a quick question. So what we voting on is the site itself and not the restaurant or the package store to be able to have, to sell liquor on the site. Is that correct?
Correct. That particular land use at that location.
Okay, so it has nothing to do with whether it's a restaurant or a package store. It's the site itself to be able to obtain a liquor license. And also, Ms. Bush, you had stated that the neighborhood was in agreement with it. Did you guys hold some type of meeting, or how did you guys, speak with the neighborhood about it?
In this case, we did not hold a town hall meeting or anything like that. It would just be the responses received from the notification of the fact that this was happening.
Okay.
That everyone has been in agreement. We also initially looked at this property for a rezoning
Yes, we
and
did.
held a hearing on that.
Yes.
At which I recall at least one neighbor, maybe more than one, appeared and spoke in favor of it, because it is a revitalization of the use. The restaurant has been closed for quite some time, and the neighborhood is wanting. And while it is, as you stated, a use that would apply to the site as a whole, they're not intending to do any modifications to the structures. So, the structures would remain as they are, with the larger being the restaurant, and then the smaller side building being used for the liquor sales off-site. And I would just remind the board, while this is all healthy discussion, and of course we appreciate a robust presentation, really what we're looking at here today is whether or not the criteria of the code has been met to allow for this conditional use. And staff's findings, as well as our presentation, all presents that the criteria has been met. So if there's something we can address related to the code criteria that causes concern, but even, access to the site, the transportation, all of that is addressed in the criteria. And I agree with Mr. Jones' statement that Patricia may be functioning as a minor arterial. I've driven the area in preparation for this hearing, and it's certainly not a narrow, you know, neighborhood type road, at least not in the location of this building. It's relatively wide, and, you know, when you're driving it, it feels like you're still going down Fairfield or one of the other larger streets.
We do have in Escambia County a large number of streets that are classified as local streets, but they collect traffic from other side streets and funnel them north and south, east and west. If you think of, you know, Bowman, Ashland, Fowler, any of those roads are similar in that they're local streets, but there are neighborhoods that connect to them, and they're essentially functioning as collector roads.
I only bring that up because I know that there's a lot of things in the code that base their ability to do different uses based on whether or not they're next to or within so many feet of an arterial road or a collector road or what have you. So if it's important then, it's got to be important now.
So you're referencing to location criteria? And those are for each different zoning district, you have location criteria. That falls in when you're looking at the rezoning and at the development review stage. There's options there. There's a process whereby someone, you'll see this generally in a rezoning, they'll turn in a compatibility study. Quite often that has to happen when we have these infill type ideas like this. You know, before the county got zoning, anything went anywhere, essentially. So you do have a lot of these legacy commercial type buildings that wouldn't and may not today meet that requirement, but that infill type provision is how staff handles those that may not meet each district's location criteria.
Can you show me an aerial of the area?
And just for your information, we did, for the rezoning case, provide a compatibility analysis for this as infill development and the compatibility with the surrounding area. But
So-
because that's not one of the criteria in the code for conditional use, it's not included here, but it was given to the county.
On that rezoning case, it didn't actually go to the planning board.
Well, it went to the planning
Oh.
board, and we were, I believe, seeking commercial initially, with the idea of it being a bar.
Right.
Because of the surrounding, area, it would have been spot zoning. The county staff and planning board wanted to give us high-density mixed use, which, when we looked at it, even high-density mixed use would have required the conditional use approval for the liquor sales for the package store. So rather than coming back to the planning board for high-density mixed use and then coming to you guys, we just came straight to the BOA.
Can I also ask you a question? The package store, will it allow in-store consumption?
Absolutely not. No.
Okay. And one other question. It's my understanding, let's assume for the sake of argument, that there is no package store involved in this matter now. It's just the restaurant. Did I understand correctly, as a matter of right, you can have hard liquor sales within the restaurant without BOA permission?
Yes, sir.
That's a matter of right.
Yes, sir.
So the question, again, help me, boils down to whether or not we should grant this application for sales from the package, or to allow the package store to operate. Is that right?
Yes.
Is that in a nutshell?
Yes, the ultimate question is whether or not the allowance of sales of liquor, bottles of liquor from the site has met the criteria of the code. But yes, the question is not related to any sales of liquor within the restaurant. That's allowed. It's just whether or not for off-premise consumption, there can be liquor sold from the site.
Right, and so really and truly, the restaurant is not involved in our considerations as to us granting it any authority to sell hard liquor.
No, sir, it's only involved to the extent that it gives you an overall picture of what the ultimate site would be developed as.
And I appreciate you clearing that up for me. I have to say, and this is not intended for you, I am disappointed at the way this was presented by the staff report, because the way the staff report was presented was just the opposite.
Yeah.
And it just isn't helpful. And again, I don't mean to be critical, and I guess I am being in a way. It's not helpful to us that have to make this decision if we don't understand what we're supposed to decide. And I'm just disappointed at the way this was presented. This doesn't have anything to do with a restaurant. This is strictly a package store issue, and it wasn't, if it were presented like that, it would have given us all, at least me, last night when I went over this file again, I'd have a different perspective than I'm finding out as it is unfolding this morning.
So according to this map, we have heavy residential north of, on Patricia. Is that correct?
Yes, that's all residential up that way. There's a
Okay.
lift station that is just south of, if you would zoom in, that is just south of the mobile home park on the west side of the road. But those are all residential neighborhoods to the north.
What's that thing with all the cars right there? Looks like a whole bunch of cars. Yeah, that, what's that?
Mobile home park.
That's a mobile home park.
Oh, mobile home, okay.
That's a mobile
It
home
just
park.
looks like cars
And-
and numbers.
Yeah,
Okay, so
it's
you
a mobile
have
home park.
a large mobile home park. Go south.
Yep. So you go south to where it connects with Fairfield, and you have commercial
Commercial
uses along Fairfield.
Absolutely.
Okay. Okay, it looks like it's, looks like a two-lane road. Patricia's a two-lane road? Yeah, okay. That's what I needed to know. Thank y'all.
Ms. Bush, would you like to go ahead and sum up your presentation? And I think we're getting down towards the time. I know you're anxious to know how we, and the board is anxious to make a decision, so.
Yes, absolutely, Mr. Chair. I will avoid going through all the criteria, but just remind the board that as outlined in our submittal, which is part of your record for review, and as presented by the staff, we have met all the criteria of the code. The adjacent properties are vacant and undeveloped and will not be developed due to the wetlands. The wetlands do create a natural buffer. You know, this is an adaptive reuse of this vacant parcel that's remained dormant for quite some time that would really breathe life back into the community. It's by a well-respected entity here in Escambia County. They run their establishments well. They don't have problems with, you know, any nuisance conditions. And, you know, the creation of a nuisance is something that staff looked at in preparing its findings. You know, I am anxious to see how the board votes on this. I do believe we have, you know, met what's required by the code, and really that is the ultimate question before you today, is whether or not the criteria has been met based on competent and substantial evidence presented. And I believe all the evidence presented by both staff and in our written submittal supports and approval of this, you know, if I could see into the future, I would know how you're gonna go and may be willing to offer, if it's your concern about the existing residences there to the north, rather than denying this based on something that's not a criteria of the code and us going through an appeal to circuit court based on the criteria of the code, we're happy to hold a town hall meeting, but and the reason we didn't in this case is because we had the rezoning with notices sent out to all the radius in which only people supporting came in. My understanding from staff is that the only phone calls they've had on this have been supportive comments related to what we're asking to do. So we would just ask that you look to the criteria of the code, find that we, along with staff, have met that criteria and grant the conditional use. But before you deny it, if you direct us to have a town hall meeting, we would do that.
Mr. Chairman, I have another question.
Yes.
I understand you didn't have a town hall meeting, but that you did mail out information to all the neighbors regarding this proposal?
Correct. All neighbors received notification of both the rezoning and what was happening there and this meeting today.
Okay, in that notice, did you identify that you were requesting a package?
It did not use the words package store, no, sir.
So, would someone reading that document that you sent them, give them any indication that there was a packaged goods?
They were
Store?
notified that there would be liquor sales, but it did not say package store.
So the neighbors could be as confused as we are. It's not a restaurant request for liquor sales inside the restaurant, but a drive-up liquor store.
Potentially.
And I'm anxious to hear the findings decision as well. But I do not want, Mayor, is this up to you? I mean, we could, since they're indicating that they were confused on staff findings, but staff findings still supported with the presentation that we presented today, staff is still in support. And they're indicating that staff did a poor job, and I don't want that to be the case of anything being denied because of something that maybe that we have done. And we could, if there's opportunity for another meeting, and we'll pay for the ask again, because I like to be clear for the board. I don't want the board to be said based upon what staff did, and then that's why if it goes up to appear, that could be a concern. So that's why I want to, that alternative is on the board, is on the table as well.
I have a question as well. That meeting that they did have, what time of day was it held at?
Oh,
Do
the
you
planning
recall?
board was set in the morning time, the rezonings,
Okay.
the exact time, I mean, it was.
So I
it
just
was-
don't, basically, I don't want nobody to hold it against the community for not being there. Because everybody don't have the flexibility the way some of us do as business owners or whatever we do. People have to work, and, so I don't want, it to be put out there like everybody's in agreement of it because, they're not here basically. They have to work. People have to work. And some people, I'm glad he brought up about the notices, where they plain, where they can understand that it was a package store. I'm here to abide by the law. I'm not a drinker, but, I'm not gonna turn something down because I don't do something. I'm always try my best to do what's right. But I do feel like the community needs a fair chance with a plain understanding of what's going on. And everybody don't understand the same. It's not a one size fits all when it comes to individuals. So,
And let me clarify something. I want to be clear. The notice said liquor sales. And that's what the code says. the code says liquor sales. Everyone that received notification, if they had the term liquor, and believe me, we have had cases where it was rezonings per se. It's not a rezoning, we need to be separate. Where the intent, where you're gonna have alcohol as one of the permitted uses, they show up tremendously. So when the code says liquor sales, we have to be careful that we stay within the bounds of state law, indicating what the code says. Whether or not it's gonna be a package store, because we don't, then they said, so the code didn't say that, the state law. We have to be careful when we do our notification on what it says. Liquor sales is indicating that this site will have the opportunity to sell liquor. That's rational, plain language of the way we interpret these things. Plain language, the opportunity to sell
But there's a
liquor.
difference between I'm gonna sell you an alcoholic drink and I'm gonna give you a fifth of bourbon.
I understand that, but I'm saying you're right, but I'm saying we have to go by what the land development code says we do our notifications. So that's why we send out what the notice is per the land development code. I understand the intent, I understand the understanding, I'm not saying that's not rational thinking, but this is what we got to do.
But
Per- if not-
you're making these citizens have to question, what does that mean? Does that mean off-premise liquor sales? Does that mean I'm going to have a Jack and Coke? I'm gonna have, a fifth of vodka,
I understand, Ms. Bass, but this is why we have these meetings, so that if there are concerns, they can kind of have the question to come and ask questions like we do, like we have had. But again, I can't, we have to be very careful when we're doing these notifications.
Can you
I
s-
understand.
Can you include the language of off-premise? Because the way I read it, it was, this restaurant's gonna sell
Alcohol.
liquor, and you're gonna have a drink whenever you eat your
Dinner.
chicken cordon bleu, That's the way I read it.
Yeah.
I didn't read that he was gonna come and get his vodka, and then come back and get his bottle of rum, and then come back and get his gin, and then come back and get whatever else you drink.
Right. Essentially, what threw me, and again, it pains me because I appreciate our staff so much to say it, but this really was never about the restaurant. This was all about the package store, but that was never, the staff findings never talked about that. It's only when you piece it together this morning and sort of like for me last night, I have no wish. I think really we need, Lord knows we need economic development in that area. And a restaurant functioning there would surely, I would think, be a good thing. And they have by right now, as Mrs. Bush has stated for the record, the right to sell alcoholic beverages. The question that we have before us is whether or not the package store proposal, which essentially was not addressed. I know Mr. Jones mentioned that the staff would be willing to go back and readdress and actually rework the findings, if I understand his thought pattern on this, where the central question is going to be presented whether or not there will, the virtue of having a package store there and whether it meets the requirements, and not confuse it with this restaurant issue.
Now, Mr. Chairman, if I may, I did hear you say something, but I want to make sure I understand what you're saying. So, under the permitted uses on retail sales, it says, but excluding the sale of liquor. It says, and then the permitted use restaurants, including on-premise consumption of alcohol, but excluding drive-in and drive-through. So if I go to this restaurant and I'm having dinner and I want to have a beer or wine, or I want to have a mixed drink that comes with my meal. But that doesn't mean that I can go in the restaurant and say, hey, I want to get a burger, but yet I want to get a Jack and, or I want to get a vodka, and I'm buying just the bottle and leaving. So
Right.
it's,
Yes, ma'am, I understand that point. That's not the building we're talking about.
and actually, they talked about restaurant, and they didn't distinguish between buildings. It's just a restaurant
Well, but
with also a liquor sales.
Okay,
I
so-
know it, but the facts do.
Okay, so,
For
I
the
mean,
sake of everyone's peace of mind.
yes.
The applicant, I've spoken with the representative for the applicant. Unfortunately, Mr. Trukowski is in Atlanta today and not here, but there is someone here for him. And we would be willing to go back, send a notice to all notified parties and say liquor sales for off-premise consumption, and then put a sentence in there, the proposed development includes a package store or liquor store or something to that effect. However, I would remind the board that that's not a requirement of the code, nor is general objections related to alcohol a criteria of the code. It really comes down to, have we met these specific criteria related to site design? Where are the garbage cans? Where do the lights go? How is it buffered? I mean, that's what you're looking at. The code allows this as a use, but says, because it is this type of use, you have to make concessions related to lighting, related to access, related to, where is the dumpster placed? And that really is the question before the board, not whether or not a liquor store is bad, because the code allows for liquor stores. It's just these additional criteria have to be met. But I realize you've spent a lot of time, and, I'm before you a lot, and to continue to have goodwill with the board, and rather than have this denied based on an idea that a liquor store is bad, or that the neighborhood would object to a liquor store, I would rather have an opportunity to have a meeting at night at a community center. We do it all the time, where people are invited out, come between, 5:30 and 6:30 to, if you have questions about the development, come back before you next month. Mr. Jones has advised that we could get back on the agenda next month with, to be able to report, we sent notice to this radius of people, and if you want to tell me what radius, I'll send it to as big as you want to go. But, the facts remain that you're really here to look at whether or not we've met the criteria of the code, and we have.
And this is the thing, and I do not want this board to because I don't drink, but we will have to make these determinations based upon the findings, not based upon what we think or what we may like or not. I don't know for certain that our findings will change, because the code does not give us specific determinations about package stores. If there was some criteria that was pertaining to package stores, but this is the criteria, and Drew and we will have to basically look at it to make sure that it meet the intent, that it meet the purpose, that it meet the black and white language of the LDC with these criteria. So whether or not our findings may change or not,
Well, I would submit to you that your
Yeah.
findings won't change.
Correct.
Because
I don't yet.
liquor sales, it's no different than if the restaurant had a side corner with a
Right.
stocked bar that said, on your way out the door, you can pick up a bottle and go. The fact that it's in a separate building,
right.
Mr. Chairman.
So Bill, you can make your decision if you.
Is it fair for me to make a motion right now?
Yes.
To take Ms. Bush, is Bush
Bush.
up on her offer, and, we see this next month after the community, has a opportunity after work hours, to, know what's going on, whether they show or not. And then I feel like Ms. Bush and, people that she represents, have a more fair, vote at that time.
Let's be clear now. Just because I want to be clear, just because the whole now this is not like the planning board. Just because this is more specific. Just because a whole bunch of citizens may call me and object to it because they don't like it, I still not. I can't be subjective in my determination based upon they just don't like it. Or because she may have 20 or 30 citizens showing up, that'll be on her. You understand what I'm trying to say? I got to be fair. If not,
I
could
totally
be
understand.
challenged.
I totally understand, because, like I say, I'm not a drinker. I'm ready to make a decision today, if need to be. I just don't feel like, honestly, the rest of the board, some of the board members aren't comfortable of making a decision based on how it was presented, and I understand that. And, if, she's willing and agreeing to come back next month, I think that'll be good, especially if the neighbors, I'm always concerned, like you say, 100 people can come and say, hey, we don't want it. But like I stated before, we still have to abide by the law and make sure, if you guys are meeting criteria for whatever you're here for, we have to make our decision based on that, on facts or findings. But because we could go on and on, we could throw rocks over there at staff, we could throw rocks wherever we want to throw it, and we're not going to get nowhere this morning.
Right.
So, if I can make a motion for us to just move on into next month and, get it together and come back and give Ms. Bush a fair vote.
You've heard, Willie has made a motion, if I understand correctly, that we would just continue this matter until next month. She's graciously, on behalf of the applicant, indicated that a public hearing would be held.
It will be a town hall based upon them. Staff won't be involved with that town hall. I want to be clear for the record. It will not be a public hearing. It will be a town hall based upon their doing. They pay for the notifications. They set it up. They get the location. Staff won't have anything to do with that. I want to be clear for the record because we are being taped and it is a quasi judicial proceeding.
That there will be a town hall meeting that Mrs. Bush will coordinate, I would. And also, the only thing that I would add to that is that we do review the findings in the way they were presented, and to include language that we're talking about a separate building and a takeout, basically, a package store included in this arrangement. I think that would be helpful for the record. And I believe that I know, at least as far as I'm concerned, that would be helpful to me in my decision. And again, I don't mean to sound like I don't appreciate the very hard work that the staff does. Lord knows I did it for 37 years, and it can be a thankless task sometimes. So, but if we might just address the findings so that we know a little more about what we're talking about, that would be good.
So Ms. Meredith, would you be willing to present more of a narrative? But basically, findings still gonna be the same because criteria of the court still got to be met. But based upon a narrative for the record, so that we can go off of what you're telling us that you really, your intention, would that be sufficient? Because the findings, I don't think the findings would vary from us, but for the BOA, so they can be clear going forward, and we can put that it's gonna be a package store per se in black and white language when they can read this again.
Yes, I'll update our submittal to include the words package store.
Okay. We have a motion by Willie. Do I have a second?
Second.
We have a second. All in favor of continuing this
And we'll pay
proceeding
for it. We'll pay for the advertisement.
until next month? Please raise your right hand. And what do we have? How many? Is it 5-1? Well,
Let's do the vote again because I was confused with.
All
Do the
right.
vote again.
okay, we will now, or I'll tell you what, before we do that, maybe I thought that, I had a feeling we probably talked this thing to death, but is there a feeling, I guess I'm obligated to ask this question, is there a feeling that we decide this matter this morning? For discussion purposes, there is a motion on the table. Does anybody have a thought on that? Or would we like to continue it to the next month? No, I think Ms. Jones
It was like,
asked.
some people, they was doing this, went back here. Yeah, that's why I said, they went, it wasn't, so let's be clear.
I
Okay.
stand with that motion if there's no further, discussion.
You stand with the motion?
Yes, sir.
All right.
I stand with the motion.
You stand with the motion? Okay. Then, all those in favor of continuing this matter until next month, raise your right hand. We have, what, 4 to 2?
4 to 2.
Is that right? 4 to 2.
Okay, thank you, sir.
And thank you, we appreciate your patience, Ms. Bush. All right. Well, now, we move to our next case. This is case number CU 2024-06, 4735 Mobile Highway, conditional use
Yeah.
approval to allow a restaurant not among the permitted uses. Did we just do this one? Uh-huh. All right.
Another case.
Okay. Can we go back to the agenda? My agenda just ran out. Okay. All right. Our next case is CU 2024-05, 1100 North Blue Angel Parkway to allow a salvage yard. Robert Chilco, owner. Is Mr. Mr. Chilco with us today?
Yeah.
Oh, okay. Would you like to come forward?
And Mr. Chairman,
Yes.
Mr. Chairman, if I may, want to introduce the board to Melissa Shirley. She's a new planner with our office. She handled this case, and she wasn't here for the staff swearing in, so she's going to be sworn in at the same time as the applicant.
Mr. Chilco, did I pronounce your name correctly?
Chelico.
I'm sorry?
Chelico.
I'm sorry.
It's okay.
Chelico,
Yes,
okay.
sir.
I butcher everybody, so please forgive me. And welcome. We're glad to have a new face to join us. All right. Let me ask the clerk if she will swear in you, sir.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Yes, I do.
Thank you.
And sir, did you receive the findings of fact from the staff?
Yes, I did.
Did you read them, sir, and are you in agreement?
Yes, I read them, and I do agree with them.
Okay. Let me ask the board, are there any, has there been any ex parte communications regarding this matter by any board member? All right, seeing none. Is there knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Okay. All right, sir. Would you like to make a short presentation, or would you like for the staff to make their presentation, and then you can, of course, make whatever additional comments you'd like?
Okay. Yeah, I would like to defer to the staff, please.
Okay, all right. Andrew?
I do want to point out, so just so you know, you are going to need to, at some point through this, go ahead and address the criteria, and you need to make your case. Staff is not responsible for the applicant's case.
Right.
Melissa, I'll let you.
Hi, my name is Melissa Shirley. I'm an urban planner. I'm here with Escambia County.
Ma'am, could
Oh,
you?
I'm sorry. Can you hear me? Sorry.
Okay.
I'll use my big voice. Okay, my name is Melissa Shirley, and I'm an urban planner here with Escambia County. This is the location map off of North Blue Angel Parkway of the existing parcel. This is the zoning around the parcel.
And if we could, just for 1 second, I'm sorry to interrupt. Since it's topic of the day, I thought I might refresh for everyone. The zoning on site, heavy commercial, light industrial, NA, refers to no alcohol uses. This was something that was done back with the old code, that it was an option if to sever alcohol uses from heavy commercial, light industrial, which at the time was C2. This property was rezoned in 2014 to C2 at the time, NA, which then converted in the new code to heavy commercial, light industrial, no alcohol. Sorry.
Does it have,
Alcohol or liquor?
No form. No form at all. Thank you very much.
so now there's no right to sell alcohol or liquor, however you want to call it on.
Is that a new zoning? I've never heard of that.
This came about back in, it's been years ago, more than 10 years ago. We just don't have that many of them.
Yeah.
It was given, the BCC, put forth this idea as a way of, let's say somebody wants a heavy commercial, light industrial zoning, and there's folks nearby, neighborhoods nearby, that don't want any of the alcohol uses, that the applicant can ask for this designation. So they could do whatever they needed to with that heavy commercial, light industrial.
But they can't sell alcohol.
Correct.
So they can have a cement plant, but they can't sell alcohol.
Correct.
Oh, okay.
Because remember, y'all don't do rezonings, but when property comes in to be rezoned, it's not site plan specific, okay? If I come in and say, hey, I want to rezone this to commercial, to build a store, well, it doesn't matter what I say, because once that property is rezoned, every use that's allowed by that zoning district could go in there. So this was the board's solution to resolve those concerns.
Can you put that designation, that NA designation on any zoning?
No, someone would have to request it at the time they go to
Right, they would
rezone.
request it, but could it say commercial NA
No,
or
no,
R2,
it's specific to this, heavy commercial, light
Heavy
industrial,
commercial, okay.
which is,
That's
it brought in all the old C2 district uses.
Okay.
Okay.
History lesson.
Yeah. All right, sir. Where were we?
Oh, sorry. This is also the 500 foot radius of the future land use in the location. And this is a aerial that shows the wetlands that are located on this parcel, which is pretty extensive. This is the public hearing sign. This is looking onto the property from the entrance at Blue Angel Parkway. This is viewing further into the property from that entrance. This is looking at the salvage operation. As you can see to the right, there's a structure there for work to be done. And then this is looking southwest from that same entrance down Blue Angel. This is directly across west from the parcel. And then this is looking north, again from that same entrance Okay, so the requested conditional use was to allow for a salvage yard with outside storage and towing activities. The conditional use is salvage yards not otherwise requiring approval as solid waste processing facilities. For general compatibility, the salvage yard could be conducted and operated in a manner that is otherwise compatible with other HCLI zoned properties. It shows the site is already conducting such business. The facility and services, the applicant, again, has existing utilities as necessary to conduct the proposed salvage and towing operations. For on-site circulation, ingress and egress would be accessible through the existing driveway connection, which already had a DOT permit for that. It's the responsibility of the owner to ensure that the tow truck would be able to maneuver in and out of that existing driveway without obstructing the traffic along Blue Angel. Nuisances and hazards. The applicant is requesting the additional use of salvage activities to the existing automotive repair and used auto sales. And this would be incumbent upon the applicant to not create any new nuisances with the new proposed use. For solid waste, again, there's already adequate for the for the current use, which is automotive repair and used sales. And he would just need to, again, that would be incumbent upon the applicant to properly continue to screen all of those solid waste from view. And then again, with this property, we're looking at a similar situation. This parcel is buffered quite extensively by wetlands along the corridor and local area there off of North Blue Angel. And then for signs and lighting, there is an existing on-site pylon. So the signage will have to be permitted for the change of use, stating the new use if approved. Site characteristics, everything, size, shape, location, and topography appears to be adequate to accommodate the proposed use of salvage activities. Yeah, I think that's pretty much everything.
You, you finished your report?
Yes.
Oh, I'm sorry. I'm sorry about that. Staff findings is that the applicant has submitted the documentation to address all the conditional use criteria, and I recommend approval for the conditional use as requested.
Sir, would you like to make your comments now?
Yeah, I haven't done this before, so I'm not really sure how to present this case, but we've been operating a towing business, mechanic shop, since 2014 when I purchased the property, shortly after it was rezoned. I started the formal development review in 2020, and I thought I submitted my payment and I submitted my application, and I thought that that was actually as a result of a code enforcement violation. And I thought that development review process had been completed. The code enforcement violation case was closed at that time, so I just assumed everything was good to go. So we had another code enforcement violation brought against us last year, and as a result of that, just recently it exposed that we are not supposed to be storing vehicles outside for more than 72 hours, which obviously is part of a towing operation. That's not you can't conduct a towing operation and only store vehicles outside for 72 hours. So at that time, it was recommended to me that I go in for this conditional use. So that was the reason behind doing this formal application for conditional use. Like I said, we're really not looking to change anything in our operation. This business has been in operation for 10 years, and we really haven't had any complaints from our neighbors. We try to be a good neighbor. If there's anything in the review process that needs to be addressed, we'll obviously address it. So.
Do we have any questions for the applicant?
Yes, sir. Oh, I just have a quick question. How do you guys prevent, like, oil spills or like leaking vehicles from, just contaminating the area in the back there?
So, we do have a work area. It's concrete. It's a 1,200 square foot work area attached to a shop area, and that's where the mechanic does his work, and he is responsible for disposing of antifreeze and oil. He does have a manifest. He does properly dispose of any fluids that are in the vehicles that need to be removed. In terms of salvage activities, we're not really dismantling and doing anything, out in the yard itself. So we're not really having to be concerned with oil spills and things like that. in the yard.
From my understanding, salvage vehicles that wrecked or something may have happened to them and they get a salvage title, is that correct? And do they come in leaking sometimes, while they're sitting back there? I mean, how do you prevent that?
So most of the fluids that are, so we're a towing operation, so we're towing for law enforcement. We're going to remove disabled vehicles off the roadways. Most of what happens in terms of spills and whatnot happen there at the accident scene. And we're just basically responsible for putting oil dry on the road to absorb any fluids. We're not responsible for actually removing the oil dry with the absorbed fluids. They're left at the scene of the accident.
Okay, basically, my question was just for the yard, once it gets there, say a car has a bad oil gasket or something in the oil pan, and it just leaks on a daily. Mm-hmm. That was my concern, how do you guys prevent that, stuff like that from happening in the back there?
Yeah, so other than the yard being completely graveled, we don't put like a oil pad or something down under each car as we bring it in. So we're really not, if there is a leak, there will be an occasion where some oil or whatnot will leak onto the ground. Yeah.
All right, thank you.
Mm-hmm. You're welcome.
Any other questions?
I have a question. Maybe for Drew or Melissa. I got it right. Is this considered an after the fact permit?
So,
I wanted Melissa to answer it.
oh, I'm sorry.
I do believe this does impact due to prior existing use, that this was requested after the fact.
You said that in 2020 you had a code enforcement violation, and then again a year ago you had a code enforcement violation. Can you tell me what those were?
In 2020, somebody stated that our property wasn't properly zoned for the activities that were taking place. and that turned out to be false. The rezoning that happened in 2014 didn't, whoever's responsible for updating that information on the website didn't update the fact that we were rezoned. So that actually turned out to be false.
Well, in
But as a
2020
requirement of that, we were told that we never formalized our development review. So we needed to formalize our development review. So that's when I did the application, submitted it, and I never received any comments. But code enforcement said that they were gonna close their case when that process had been completed. So code enforcement is the one that I was in communication with. They contacted me and said they reviewed everything, it looked like everything was good to go, and they closed my case. I never did receive any comments from Development Services, so I just assumed it was good to go. The most recent code enforcement had to do with vehicles that were put out in front of my yard. And so it was more of a cleanup type code enforcement violation, that I had cars that shouldn't have been out front that were disabled.
Like on the right of way, you mean? When you say out
No,
front,
not on the
is it-
right of way. More, I was using the vacant parcel that is to the north of me to store some cars.
Oh, okay.
And then at that time, I was told that I couldn't have any cars, whether they were disabled or functional, out front. And that's when we got into this conversation about the fact that I thought as a car lot that we could have cars out front. And then we started talking about outside storage of vehicles, so.
Okay. Horace?
Yes,
I've got-
again, let me, yes, it goes back, but the gentleman, we met with him a couple of months ago, about a few weeks ago. He came in trying to make it whole and complete. There was some, perhaps, miscommunication that was done on the part of another agent that was in violation, that was looking at the code site. So that's neither here nor there. He came back in, we met, we gave him a path to go forward. It appeared there's an existing car lot. Now he want to, again, this multiple use. He want to have savaging activities with this type of use, with this use as well. Now, the whole site will still have to go through the site plan review process. And he going, this time, he know he got to complete it. There was some miscommunication that was done. But he came in, he said, thank you, Mr. Giacometti. Let's try to get me whole and try to comply if the board with everything. So it is a use. Now he wants to have conditional use approval for savaging activities. The whole site, again, going to still have to come back to the development order so that he can make sure, once he start, if the board approve the development order for conditional savaging, he can have that use. And if they does not, he's still gonna have to have site plan review process for the other operation that's ongoing. That's
And
in
my major,
operation.
my major concern is this has been going on for 10 years, and this has been a salvage operation for 10 years, and it's located right by a wetland, which I believe is connected to a larger wetland, and we've got cars here that are deteriorating and leaking. I would be willing to bet that at least 50% of those cars have started leaking without anyone's knowledge, and we're leaking into gravel area which is running into the wetlands. And my concern is any environmental issues being looked at during this site plan process?
It will be, believe me, they will be. They will be looked at, you're right, because you're right. They will be looked at it wholeheartedly. And and according to the officer, which is not here, I think the site, a whole bunch of stuff been cleared from that picture. So code enforcement, he has made some cleanup activities because of the citation. Now he just gotta try to comply with the rest of the regulations. Now, just because the use is in operation, that still don't mean that it complies with the code. So, but that's neither here nor there. Now he's trying to make it whole, to give the opportunity to a path going forward. That's what we, if the board so desire. But the site plan review, wetlands, all of those things will be looked at. Mr. Drew Homer and our team and stormwater, we're gonna look at that wholeheartedly.
What is the buffer that's required for this type of use for a wetland, next to a wetland?
So they need to average a 25-foot buffer. I would caution the wetlands layer, that layer is for reference only. When
And it may be more, and it may be less.
correct, you can't really make decisions based off of that. It is simply an indicator that there are wetlands in that area. It would require flagging to go out.
Can I add to this,
to
please?
see.
If you look at page 26 of the case findings, that actually gives delineation that was done by Wetland Science
There you
in
go.
2020. I had that updated. I actually had it done originally in 2014 before I ever started operating the site. And then I had it as part of the application that was done in 2020. I had it updated on April 24th of 2020. And so, and based on that, we actually pulled out some of the, where it's real close to the boundary, we actually cleared off several of those cores so that we have an appropriate buffer. So we are very aware of the wetlands on the site, and we aren't trying to get in any trouble with the environmental people.
So we go back to this thing. So what you're here before us today is for conditional use to allow a salvage yard. And the definition of a salvage yard is what?
So, not to get too deep in the weeds here. Our code doesn't address what's considered an impound lot. We don't go there. And when it comes to salvage activities, if it's a matter of vehicles being placed there and parts coming off, going in and out, that would come to this board as salvage yard that's not processing the vehicles, okay? That goes to the Board of County Commissioners as a conditional use. But that, if, the difference being, if you've got vehicles that are being stored, you may be taking some parts off of them. That's not the same as rendering vehicles into something else, as in recycling, crushing, tearing them apart. That's where it falls into that solid waste processing. So if it's not a recycling operation, a solid waste creator, it falls under this vague category of salvage operation.
And definitely, thank you for that. It's very good, just what definition. That's why we, an industrial facility or area for the collection, storage, sale, salvage, talking about salvage, y'all, or exchange, disassembly, shredding, compaction, baling, or other handling of scrap or discarded material or equipment for salvage, including metals, paper, rags, tires, bottles, and cans, motor vehicles, machinery, appliances, and structural steel. So it's a very, very broad category. That's why the code says conditional use approval for these type of activities. That's what he indicating that he would like to do along with his existing operation.
And under that, as Mr. Jones was saying, under that very broad umbrella of salvage, this is on the lighter end and it comes to this board.
Right.
When you go to the heavier end where you're rendering
Absolutely.
materials into something else, that's when it goes to the BCC.
Yes, it does.
And you may not know this answer. And I go back to the fact that there's a huge wetland. And that's my ultimate concern here is, does EPA or any other agencies have an idea that this is going on? Is it something that is regulated, this activity regulated by, and maybe you know, the state as far as these chemicals and the removal or containment of such chemicals?
Not to my knowledge, but I understand the concerns. I just don't agree that that is what's happening with these cars that are being parked in the yard, that they're deteriorating and leaking fluids. That's not something that we see. That would
You don't
be-
think that a 10-year-old car that's sitting outside
Yeah.
won't
Well,
deteriorate?
we're not keeping the cars for 10 years. I mean, we basically, again, this is more to support my towing operation. We're not trying to be a junkyard. This conditional use is really to just allow a longer storage period for the vehicles that we're impounding through our towing operation.
Okay, how long are they impounded for?
Well, I would say we can safely say that within a year's period, the cars would be removed. But in terms of the impound, I mean, a normal impound is gonna be, maybe, so in terms of the towing operation, there's a tow and storage lien process. So when somebody doesn't claim a vehicle, if it's a newer vehicle, we have to hold on to that vehicle legally for 52 days.
Okay.
So at a minimum for those situations, depending on the age of the vehicle, it's 37 days or 52 days at a minimum that we have to keep those vehicles. So it's a case-by-case
And then
scenario.
what happens to the vehicle after 52 days?
So there's just multiple scenarios that what could happen. We do try to get, if there's no insurance involved, we do try to get the people to come in and bring their titles. And once that happens, then we can sell the vehicle as is, or we can, if it's an older vehicle, we'll scrap it. So we basically take it over to one of several local scrap yards. There's also other people that we would sell these vehicles to, just in their complete.
So this outside storage is short-term outside storage?
Correct. I would classify it as short-term, but it's longer than 72 hours.
Yeah. Because our code requires the outdoor storage of 72 hours, and that's what our code requires. But all of those concerns about environmental, we definitely would reach out to Mr. Chips Country Tim Day, our environmental experts, to look at those things, and we could put some special project conditions on the site plan review if that is a concern, but we definitely have them looking at that as well, because I understand your concern, Ms. Bass.
On your repair shop, do you have any state licenses that you have to uphold?
Well, we have the motor vehicle license that's issued by the Department of Agriculture. That's the only license that's required to do motor vehicle repairs. And we hold that, obviously we have that, and we also have our occupational license.
Does any other board member have any questions? So essentially, if I understand what you're requesting is, you would like this conditional use in order that you might have the outside storage of the automobiles or vehicles that you recover for more than the mandated, what is it, 72 hours? Or is
Yes.
that right?
Yes, sir.
That's essentially what you're asking for?
Yes, sir. Exactly.
Okay. Well, board, do we have, would you like to add anything else to your presentation?
Not at this time. Thank you.
Staff, do you have anything else? Okay.
Mr. Chairman,
Yes, sir.
I just want to understand, and those cars are gonna be there for a minimum of 52 days. You have to, you have to hold them for 52 days before you're able to do something with them.
Again, depends on the situation. If there's insurance involved, the car could leave the next day. If it's a DUI, it could be picked up, it wasn't even involved in an accident. It could be operable. It could be picked up within a week. If it's a newer car, 3 years or newer, then it's the 52 days. And if it's older than 3 years, then it's 37 days, basically.
Thank you.
You're welcome.
Can I see an aerial of this with the wetland overlay? I just want to make, can you get the maps thing? See, that's my concern, is that hasn't been looked at. And the fact that this has been going on for 10 years, and that wetland has been exposed to this, concerns me to move forward with this type of operation.
I agree with that. 10 years is a long time for it not to be a big deal. A long time.
Are there other comments?
My last comment is just, you keep piling stuff in there, it's just gonna get worse. It's gonna pile on top of that 10-year. I can imagine, I know everything come in there don't leak, but I can imagine there's some that do, and nothing's being done about it.
At this, I do want to say, there's another process for these things. If there's a concern that you want to make for him to look at, have another wetland survey or whatever, there's another process for those things that can happen. That can happen. Those are jurisdictional wetlands, DEP.
If this came to this board, and he said, hey, there's a piece of property right here that I want to start my business on. And I guess that's the way I'm looking at it, is if he came, that was a vacant parcel, never stepped foot on that property yet, and he says, hey, Board of Adjustments, I want to put a salvage yard with outside storage and towing activities. That's the way that I'm looking at this.
Huh?
Regardless of what he did in the past.
Right.
It's a brand new thing. I don't even look at what's there now. Okay? How would I approach this? Would I say, sure, put a salvage yard right by a wetland? That's a good idea.
This is, in one of the criteria, it says that a site plan review process will yet be necessary.
I understand
Now,
that.
So what
But
I'm
it
saying.
also says it comes before the BOA, and it says y'all determine whether or not this is a good use for this property, right?
And you do have that, and we will tell you, basically it's this. Based upon the information that we have now, there will be a substantial review and look at the wetlands during the site plan review process. And if there is some mitigation, if there are some protocols that has to be in place with that use to protect those wetlands, we will let him know that, and before we issue him a development order to proceed, those things will have to be looked at wholeheartedly and holistically with those things in place. That's how we would take it from there. Yes, and we do know, and with the maps, that's one thing that our reviewers will look at. Vacant lot, yes, there's a lot of wetlands. This use, how it's going to impact, and we will engage with him. He may have to get more information to satisfy the environmental reviewer that sits on the environmental team. So it would be no comfortable. He got it. There's no other review. He got it because y'all know there are some substantial level of review that we look at. So that's how to answer that question from. I don't know if that ease your concern, but it will not be no. Yes, he can do it. No other review said no. Y'all raised the concern. Then we could tell him, hey, the BOA had this concern. Look at it. What you're gonna do to mitigate, to protect, to stay out of. You got to have that. And if he and we can have higher standards. We can tell him you need to do this to protect. And those things have to be in place before he get a development order to proceed. So there are protocols that are in place when it comes to these type of use to protect those areas. Now we can't minimize everything, but we can try to provide the protection within that as much we possibly can because of the concern that was raised.
There is one thing I would agree with Vice Chairman on, if we were looking at this as a blank slate where there was nothing there, the reality of what we're dealing with is a businessman who's been in this on this parcel for, I think his testimony was 10 years. And essentially what we're trying to do now is close the barn door. It looks like to me. And so it's not this, I agree with our vice chairman in the sense that if this were a blank slate, then we would be taking at least I would take a different look at how to address this, but it's a different situation from having just nothing there, just bare land, and from a business that is already established there, that's essentially, I think, from what I can gather, is trying to get in compliance with our ordinances. I think essentially that's where we are.
Yes, sir. And you're correct. And we would take this as if this is a blanket slate as well. So, I mean, when you come in, just because you may have been there, if you have not. So whatever the regulations are, if it's mitigation, paraffin, cleanup, whatever it takes to do that, that's what we have to do once we come through the site plan review process. I understand it's sort of after the fact, but that still is an issue, and we will have to try to address it as much as we possibly can.
Yeah, and so I think when we are making our decision process and each of us casting our vote, at least as far as I'm concerned, want to look at this in the light that, and I agree with the vice chairman, this is not, it would seem, the most ideal place to have this kind of operation in adjacent to wetland, massive wetlands, but it is there. It has been there for a decade. The owner is trying to become compliant with the law, with our ordinances, and so that's a different, at least for me, a different thought pattern than if someone came in and said, hey, I bought whatever acreage and it's in the middle of a wetland and I want to have a salvage yard. I mean, that's not our case here. The case that we're dealing with is what's on the ground now as it goes. So I would just throw that out for what it's worth.
And I would probably beg to differ.
But I understand, and it's a perfectly valid position.
Well, I think that we're here today because of a new code enforcement violation. And I think that had he not gotten the code enforcement violation, we would not be here. And this would continue. And I think that unfortunately, after 10 years, there's been no regulation on this site by EPA or whoever regulates these things.
Well, I would agree with that, but
If it helps the board, the most recent code enforcement violation was 7/25 of 23. Description was inoperable vehicles in right-of-way, no privacy fence around business. That's all that it addressed.
so, but, you know, we can only work with the here and now, and what's in the past is in the past, and we can't magically uplift this business site to somewhere else. It is what it is, and I'm one for trying to address it and to get the owner, our petitioner, compliant. Because, all right, let's say for the sake of argument, and that we decide, the majority of us, to deny this. Well, I'm not sure how helpful that's going to be in the long run in addressing this situation. The salvage yard's still going to be there. There's still going to be issues with the county, I would think, about code enforcement and maybe, I don't know, environmental reviews and stuff like that. So it's, I mean, if we deny, then I don't know that we're helping the situation. If it were, like I said, a blank piece of land, virgin land with nothing on it, then it would be different. But we have a business there, and I honestly, and I fully understand about the wetlands, and I don't think it's the greatest idea in the world to have them have this operation where it is, but it is, and that's the facts of life that we have to deal with. And the only thing I can say is that we try to get the owner compliant, and if Mr. Jones is correct, is that development review, that there are going to be some environmental issues addressed at that point, that's the best fix it than not doing anything and denying. I mean,
I would hope that those environmental issues are addressed, whether it's approved or not approved. I would hope that those issues are addressed no matter what at this point, because it's been 10 years.
I think so. And I agree with you on that, that we would, I think we would, if we did approve this, then I think that then in the development review process, and as y'all know, I'm not been a fan of the way that we do the development review sometimes with some of these cases. I do feel like that we don't address things that I think are important. But in this particular case, if it's the only avenue that I see, if we don't do it, we deny it, what do we got? He's going to still have issues with the county. Oh, I would imagine, and whatever other agency that regulates the environment. So why not try to get this compliant so that at least we can do some fixes, because if we don't, we're just going to make it more difficult, I think, to achieve some compliance. That's my thought. And as I said, I just don't, it's a different analysis, as I've said before, between just a vacant piece of property and one that's occupied in the situation it's in now, in my opinion. And I invite any more.
I think Jennifer has made many good comments, and so have you, Mr. Chair. And I think right now I'd say one of you should make a motion.
Do I hear a motion? I'm the chair, so unless I pass it, do I hear a motion from anyone?
I make a motion that we accept the board's recommendation.
We have a recommendation for acceptance, a motion for it. Do I hear a second?
Second.
I have a second. Board members, are there any final comments that we would like to make?
There aren't any speakers, are there?
Oh, yes, I'm sorry, there is.
Chairman, the speaker that submitted that form advised that he was leaving and he didn't want to speak anymore.
Okay.
So you're good.
Just for the record, that was Angelo Fielder, I believe, has left the meeting and has chosen not to speak. And thank you. I appreciate the reminder. Well, if there are no other comments, all those in favor of granting the petitioner's request and approving the staff's findings of fact, I'll ask that everyone that's in approval raise your right hand. And we have 5, is that right, 5-1? We have 5-1 with our vice chair in dissent. Thank you, sir, and I'm sure if you get with Mr. Jones or one of the staff,
Thank you very
they'll
much.
instruct you on where to go from here. And our last hearing today is case number 2024-06 4735 Mobile Highway. The request is to allow a restaurant not among the permitted uses. And Mrs. Bush is the agent for Osceola Six Investors LLC, the owner. And Ms. Bush, first, let me ask, have there been any ex parte communications? Seeing none. Has there been any knowledge or information obtained from a site visit or other sources? Seeing none. And is there, I'm going to ask, any board member intends to refrain from voting due to a voting conflict of interest?
And I have that conflict. I know y'all are all hella happy about that. I have to read this disclosure. It says, I, Jennifer Bass, hereby disclose that on March 20th, 2024, a measure came or will come before the BOA, which inure to the special gain or loss of Rebel, Battle, and Associates, by whom I am retained. The measure before my agency and the nature of my conflict interest in the measure is that my employer, Rebel, Battle, and Associates, is under contract with the applicant to perform engineering services for the project located at 4735 Mobile Highway. And I do not plan to partake in discussion or in voting of this case.
Thank you. Let the record reflect that still leaves a quorum of 5 members here and able to vote. Mrs. Bush, you, I presume, did receive the staff's findings of fact, and you have read them?
Yes, sir.
And you are in agreement with the findings?
Yes, sir.
Would you like to make a short presentation now, or would you like the staff to go through and make their presentation and then you follow up with your own?
Well, just very briefly, the reason for the request, it's for a Chick-fil-A with a drive-through. The code requires that it be at least 200 feet from any LDR or MDR zoning district unless separated by a 50-foot or wider street right-of-way. In this case, there is adjacent MDR zoning at 13 Sioux Trail. So that's the reason for the request. I'm happy to let staff proceed with their findings, which we agree with.
Andrew, could we?
Yes, sir. All right, this is conditional use case, CU 2024-06. This is our location map. You can see the parcel in question highlighted in red. The 500-foot radius zoning map showing the zoning on site is HCLI. And as you can see on the south corner there, it is directly adjacent to medium density residential. Future land use for the site is commercial. This is an aerial view of the site. On this aerial, you can see the old Osceola Motel that was the structure on site that has since been removed. This is the public hearing sign that was posted on Mobile Highway looking northeast. This is the public hearing sign posted on Tonawanda. This is looking into the subject property from Mobile Highway. In each of these photos looking in, you can see there are some quite large live oak trees, and I'm going to be addressing that as we go forward. This is looking southeast from Tonawanda and Sioux. And then this is looking north from Sioux Trail, just outside of the medium density residential zoning. So we also have in the packet, and we can get to that, they have submitted a conceptual site plan. And I'm going to let you know now the presence of the large trees. This has been in discussion for several years now. Our arborist has visited the site and done an assessment on all the trees. I mentioned the site plan because once we get into development review, there may have to be some adjustments made as we try to work around the situation with the trees. Generally a commercial use, we aren't wanting it to connect onto a local street if there's another alternative. But given the sensitive nature and the size of the trees, our staff is going to be quite flexible in any measures we have to take to save the trees that can be saved. As to the criteria for this, once again, the code tells us we can't have that drive-through there because it's not separated by a 500 or 50-foot or more right-of-way. It's directly adjacent. That sends us to the conditional uses, and it says restaurants that are not among the permitted uses of the district. As to the first criteria, this is about general compatibility. This parcel directly abuts medium-density residential zoning, so it requires conditional use approval to have a restaurant with a drive-through. The use is compatible with the current zoning and uses along Mobile Highway, a principal arterial road. Facilities and services. Facilities and services are available and will be provided as needed for the proposed use. The connection to these services will be reviewed at the development review stage. On-site circulation. Based on the submitted site plan, primary access will be via Mobile Highway. Design of secondary accesses on the adjacent residential streets will be determined by existing large trees on site. The county seeks to preserve as many large trees as possible, and design considerations for access will be determined during the site plan review process. Nuisances and hazards. As shown on the submitted site plan, drive-through operations will be as far away as possible from any residential uses. Solid waste. Solid waste service must be provided as needed for the proposed use. Screening and buffering. If the conditional use is approved, the applicant must meet the screening and buffering requirements of the Land Development Code and supplemental buffering between the restaurant use and nearby residential uses. Signs and lighting will be evaluated during DRC and must be limited to what is allowed by provisions of the LDC. Exterior lighting shall be deflected from adjoining properties and public streets. Site characteristics. The location appears adequate for the proposed use as proposed. Specific use requirements. The LDC lists no specific requirements for the proposed use. And as to the findings, staff recommends approval of the proposed use as requested with the condition of pending completion of the DRC process and receipt of a development order. And that concludes staff's findings.
Do we have any questions for the staff? Ms. Bush, would you like to make a presentation?
Thank you, Mr. Chairman. We are in agreement with staff's findings. As shown on the location map and in the aerial, this property is surrounded by commercial uses. It's right across the street. To the southeast, across the street is the large Walmart Supercenter on Mobile Highway. You've got Home Depot and Advanced Auto Parts, along with a Denny's and Budget Brakes. To the northeast or northwest is a Tom Thumb convenience store. There's a Happy China Chinese restaurant, Sunny Day Spa, and Dollar General store. So the area is predominantly commercial, but there is, as stated, that some existing residential in the MDR zoning, which requires the conditional use approval. The development as proposed on the site plan includes 3 access points. There will be sufficient buffering and landscaping between the residential use and the commercial use of the Chick-fil-A. And as outlined on the site plan, the drive-through is actually to the far other side of the property from the residence, but it's still, because it's adjacent, it's less than that 200 feet and doesn't have the right-of-way between. All the other sides of the property has a 50-foot right-of-way or greater. We believe we've met the criteria of the code. I do have a representative here from the developer if you have other site-specific questions, but we would just ask that you find that we've met the criteria and approve the development or the conditional use.
Do we have questions for Mrs. Bush?
Yes, Mr. Chairman, I have a question.
Yes, sir.
Was there one down there?
No, I was just gonna take a moment to be silly because this has been a serious morning. I was just wondering when they gonna open up on Sundays, that's all.
Have there been any preliminary selection of the oak trees that will be left? Has that been addressed yet?
Do you want me to?
For the past year, we've been working.
But, sir, are you Mr. Brock?
Yes, sir.
You want to come forward if you would give testimony and be sworn, sir?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State
This
your
is-
name and address, and you can continue.
Stuart Brock, 132 Lorena Lane, Birmingham, Alabama, 35213. Yes, sir, to address your question.
Yes.
Mr. Holmore can attest that I personally have been working with Jimmy Jarrett, the county arborist, for over a year on taking measurements of each tree, having specific tree surveys done. I don't know how many specific site plans we have gone through, but I can tell you it is over 25. They have seen a lot of them. We are relying specifically on her advice to save and preserve as many trees as possible. But also we want to provide a great opportunity for the community. So,
Thank you.
How many trees are there that are in, at issue here?
I don't have the tree survey on me.
Well, just roughly, are we talking 10 or
That are of,
12, 15?
I'd say less than 10, but some of them are quite large. There's one in the center that is extremely big, but is not in as good a shape as some of the ones that are slightly smaller. And that's going to be part of this whole thing is, what's best is saving some that are almost as big, that can be saved as opposed to one that may not be in that good a shape. That's why I said there's still some more trading there to go on. But of course, our goal is to follow our code and our tree preservation ordinance.
And when do you anticipate you will be able to break ground and begin your construction?
a lot of that has to do with Chick-fil-A and how quickly we can get through the process. The Chick-fil-A deal is corporately approved. They have been down here. They have toured the market 3 different times. In an ideal world, we would turn the property over to them to begin vertical construction probably late fall of this year. I think probably more realistic would be fourth quarter of this year, and then they would look to try to go vertical maybe this time next year.
And what kind of buffering are you planning, since you do have some residential property near you? What kind of buffering do you plan to have?
Really, we would just try to meet and exceed whatever is required by code.
Okay. Andrew, do you have any idea what we're buffering wise? Will it be vegetation or fence or?
It'll be a combination of both. We would want a privacy fence, but we're also going to require vegetative buffering. Now, depending on existing vegetation, we're going to want to use that as if we can, as far as trees and everything else. That's going to go into the amount of vegetative buffering we're going to require. Obviously, if there's some trees that need to remain, we may not have them plant as many shrubs and whatnot. We don't want to disturb the trees that are there.
Okay. All right. Ms. Bush, did you have any other
No, sir.
comments?
No, we would just ask that you approve that we've met the criteria of the code.
Staff, do we have any, I'm sorry, board, do we have any final questions for Mrs. Bush? No? Do we have any final questions for Andrew? No? Well, I guess we've reached the point in time where we would need to have a motion.
Make a motion to approve according to staff findings.
We have a motion to approve the request.
Second, Mr. Chairman.
We have a second. Any further discussion? No discussion seen. All those in favor of this application, please raise your right hand. Let the record reflect that the vote was 5 in favor and 1 abstention. Thank you, Ms. Bush. We appreciate you being with us again.
Yes, thank you, Mr. Chair.
Andrew, do you have anything you'd like to?
Pack a lunch for next month.
Baby needs new shoes, so.
Well, with the addition, we're now up to
You
five.
know, bring it on.
Five cases next month.
5 cases, all right. One thing that I'd like to bring up to the staff before you go, Ms. Rachel sent, I guess, everybody an email about now you can't file apparently the paper Form 1 with Ethics Commission. I started trying to file electronically. I'm here to tell you, you best start now, because it doesn't look like it's going to be very easy to use that system they've set up. So,
Mr. Godwin, I am not technology savvy at all. I'm telling you. Sometimes I don't even know how to turn my phone on and off, and that's the truth. But I did it. I had the same reservations. Oh my Lord! I'm old school. I'm not old, but I'm just old school.
yeah.
I did it yesterday morning. I was nervous, but guess what? The directions are plain and it's clear, and I'm telling you, it's not really that. But you do have to register.
Yeah.
Once you register, they'll walk you through everything. I mean, it's really quite helpful and quite childlike friendly like me.
Well, I definitely, when you're old like me, you need all the help you get.
Well, it's smart, but I think, yeah, it's really not that hard.
So anyway, I just bring that up, that normally I'm the one that waits till the night before to do it on paper. You might want to look and try to wrestle with it, so.
Mr. Chairman, I'm at a loss. I haven't received any requests for.
Well, I'm sure Rachel will send
I'll
you
send it
the
to you
link.
again.
You got it?
Yes. It's about your Form 1, submitting your Form 1 with the Supervisor of Elections online. I believe I sent it yesterday or the day before, a second one,
Yes, I think it was the day before.
day before, with some instructions. But
Yeah.
I'll send it to you again, a separate email, just.
And it doesn't go to the Supervisor of Elections anymore now. It goes, from what I read, to the Ethics Commission in Tallahassee, so,
That's how we would check if you did it or not,
yeah.
but yeah.
Yeah. So anyway, I just throw that out. And so do we have anything from our good counsel? No. Good, okay. Well, let me close up by saying I appreciate everybody's hard work, and I appreciate the staff's hard work. And if sometimes we, at least I'm speaking for myself, and I'm sure I'm hoping I'm speaking for the board, sometimes we may not agree with the findings or how they're presented, but that doesn't mean that we don't appreciate Andrew and his staff and Mr. Jones and how hard you guys work. It's just at least I see things sometimes differently, but I did want to say that today, I guess, was an example that sometimes we have cases that we just don't see the way the staff viewed them, but that's not to say that we don't appreciate everyone and the hard work that they do. So, having said that, I'll entertain a motion to adjourn.
Motion to adjourn.
All right, I'll second that.